Good morning, everybody. Today we're going to take some time and go through the new HIPAA changes that came into our lives in January and will be effective beginning in September. I'm going to take you through the changes only. We're going to dip a little bit into the HIPAA rules themselves for a little background, but for the most part, I'm just going to stick to the changes because, as you can understand, going through the privacy rule, security rule, and breach notification rule could take all day. And I'd like to give you a brief summary of what many of you are going to have to implement in the next couple of months, so that way you have that basis. And then if you'd like further information on the rules, you can always feel free to reach out to me, or we'll do more extensive seminars probably in the next coming weeks. So I'm going to start by giving just a brief background on HIPAA. When you say the word HIPAA or HIPAA rules, we're talking about three different rules that have come into place. The first, the well-known privacy rule, which governs the protection of patient information and the uses and disclosures that are permitted by a covered entity, which a covered entity, of course, includes a doctor's office. The security rule, which came into effect only in the last few years, governs the treatment of electronic health information. So any protected health information, which will cover patient information that is in electronic form, held on a laptop, emailed, transmitted over the internet, all of that is covered. And the security rule requires that every single practice have a security policy, which is required to cover certain administrative, physical, and technical safeguards. And our security rule policy is 3 pages long. It covers everything that's required under the statute and specifies all of those safeguards that you're required to have. Perfect example is everything is required to be password protected at the practice. Each individual practice member, no matter their status, whether they're an owner or an administrative staff person, should have their own individual password, so that way you can identify who's accessing what. And that's a separate lecture, but that's some basic information on the security rule. Breach notification rule also is separate and is what you're supposed to do and identifying what a breach is and how the response should go. So we're going to dip into that a little bit today. There's been some major changes in enforcement provisions, so we'll cover that in a little bit. To get us started, I just want to go over very briefly, very briefly, covered entity includes a medical practice. So we're going to proceed understanding that for many of you listening, you work with a physician or you are a physician, you qualify as a covered entity and are required to adhere to the rules that we're going to go over today. Individually identifiable information. This is very simply anything that can be linked back to a specific patient. So if we're talking about details of a patient record that are nonspecific, for instance, diabetes and some other very generic health concerns that could apply to any one of millions of people, that's not individually identifiable. Versus a social security number, driver's license number, photo ID, picture of an individual counts as individually identifiable, which is why any of you who have cameras in your offices, you're not allowed to have cameras in areas where an individual would not have an expectation of privacy. You're absolutely allowed to have cameras, and I encourage you to have cameras, but it's how you treat the information that's being recorded. So who has access to that information? And that information must be protected. So protected health information is going to be all individually identifiable information that a covered entity has in its possession, and it is required to be protected in certain ways, governed by the HIPAA privacy rule. The HIPAA privacy rule, as I said a few seconds ago, governs uses and disclosures by a covered entity. Now, a covered entity is allowed to make the following uses and disclosures, and some of them have changed to a degree, which we're going to cover. But to the individual requesting, it's their health record. I have received a lot of questions as to whether or not, Jennifer, what about information received from another doctor's office? We didn't generate that. Do we have to give it to the patient? Absolutely. You are at all times only a custodian of the medical record, and it is a patient's record. Whatever you have on file in their folder, that is their record. If they request it, they're entitled to it. Treatment, payment, and healthcare operations is another reason you're allowed to disclose. So anything that has to do with a patient's treatment, if it's to a referring physician, again, for the patient, to the patient, payment purposes, you are allowed to disclose. Now, does this include to a credit card company that is disputing a charge? This has not been strictly prohibited. There's nothing in the rule that says that you cannot disclose. However, I do not believe that this is necessarily what it was intended for. Payment really means to the insurance company or to a patient to justify services rendered. To the credit card company, I guess you could easily make an argument that is for payment purposes. However, I would caution you that you want to make sure that you are not disclosing when a patient would not have authorized. So healthcare operations we're going to get to in a minute, but that's going to be our first change under the new rule, and we'll get to that when I get through the rest of these. So pursuant to a valid authorization, I want to caution you here. A lot of practices receive a lot of different types of requests for information. You want to make sure before you're disclosing any protected health information, you have a valid authorization in front of you. How do you do that? Well, you may not know the answer to that. So you may want to elevate the concern. You may want to contact your healthcare attorney and ask whether or not what you've received is a valid authorization. I receive those requests all the time, and you absolutely should do so, because nothing will get a patient madder than being charged for things or having information, sensitive information released without that someone is not authorized. So you want to really be careful, make sure that you have a valid authorization. You may want to notify the patient you received this authorization and let them know that you are legally required to disclose. That's a good idea as well. By agreement would be by agreement by the individual, or if they have authorized another person to have access, a parent or guardian or spouse, that would be by agreement. You are also required to disclose to requested individuals by the patient, and also to the secretary, which is essentially the government, to HHS or to the Department of Health or Office for Civil Rights, that are investigating a complaint or compliance. You're required to disclose information. So we're going to come to our first change, healthcare operations. This is a significant change. The definition used to be that healthcare operations included quality assessment. Changes that it did not include quality assessment. The new change is that it does include quality assessment, and that it includes conducting quality assessment and improvement activities. This is a very big change because all of those letters you're getting from the insurance companies for retrospective reviews where they've already paid you, or for quality assessment. If you asked me a year ago whether or not you were required to produce, I may have said, well, pursuant to New York state law or other state laws in different states, you have protection, and that the patient has to give you a contemporaneous release for the records to be released. Now we can't really hide behind that anymore. Healthcare operations clearly incorporates now, starting in September, quality assessment and improvement. So you're going to have to disclose under all of those requests, which if you've been dealing with the insurance companies in the last 5 years, if you have good documentation, you're better off doing anyway, because they just stop paying you or put you on prepayment review and make your life pretty miserable. So I understand that, and I feel your pain, and if you're having those types of issues, you can always give us a call. This is an opportunity to recognize that there's going to be a lot of increased scrutiny in your practice. I recommend that you take this as a red flag and you bring in a coding expert to take a look at the documentation to make sure that you are properly documenting your services, and that you should be paid what you're expected to be paid, because you are clearly documenting the services that you have performed. So take that with a grain of salt. It's money well spent. Make sure that you're crossing your T's and dotting your I's. But this is a new provision that for deceased individuals, under the new rules that are implemented, you're allowed to discuss with a family member or a known individual related to a care the circumstances around an individual's death, and also payment information. Now, I will caution to please keep any disclosures in your professional judgment to the minimum necessary. And the disclosures are only allowed to be made from the physician, or at the physician's direction. So if you are a practice manager and you are involved and active with patient communication, please keep that in mind, that if you are relaying information to a family member of a deceased individual, make sure that you have written down somewhere that the physician has authorized you to discuss whatever it is you're going to be discussing. That way, if it is looked into at some point for any reason, let's say one sibling receives information, doesn't get along with another sibling, and that person makes a complaint, you want to make sure that you've protected the practice and that you have in writing what's been disclosed. Again, any questions on any of these topics, you can always feel free to call me or send me an email. As many of you know, if it's a generic question, I'd be happy to answer it for free and to use it for the listserv. So feel free to do so. And, better safe than sorry, so always ask if you have questions. Patient information is now required to be given to the patient in electronic form if requested. We're going to get to being reimbursed for this, but I want to be really clear. If they want it emailed, make sure it's done securely. If you're not sure if you're using secure email, stay tuned to the newsletter. I'm going to send some stuff out on that, but you want to make sure that it's password protected. You also want to make sure you're confirming the patient's email address, and I would do that by having them write it down for you on file, making them email you directly potentially so you have an email, and make sure you have really good policies, which of course we can help you with if you need, that specifies that they're the only one who has access and is password protected, and that you are absolutely 100% authorized to communicate with them via email. If you're going to be communicating with them or giving them records on a storage device, you will be able to charge for that, which we'll get to in a minute. Time for a request. You are not allowed to dilly-dally upon receipt of requests for patient records. You must respond within 30 days unless there is some sort of act of God or overriding reason why you cannot do so, in which case I would let them know in writing why you cannot respond within 30 days. For instance, if there's a hurricane or your office has been vandalized and the records have been destroyed or by fire, you want to make sure you have a written record of that regardless, but you're certainly going to want to make sure that you have in writing to the patient what happened and why you are not able to comply with the request. Fees. Touched upon this briefly a couple of slides ago. You are now authorized to charge patients for more than the amount of a piece of paper. And of course, this is correlating with our new area of production. You are allowed to charge for labor and supplies and postage, and also preparing an explanation or summary of the PHI that's being given over. Now, it has to be a reasonable cost-based fee. So if you're going to start charging for this, and I recommend you be extremely careful, because a very easy way to get reported to the Office for Civil Rights, which is who monitors HIPAA compliance, is to charge a patient something or anything that they don't think they should be charged. So you want to make sure you're giving a very detailed itemized receipt and that you can substantiate any amount that's being charged. I've dealt with a couple of inquiries from the Office of Civil Rights investigating clients where they've been charging for record production, and I can tell you it's a very unnecessary expense for the client to incur to have to hire a lawyer to speak with the Office for Civil Rights. Now, unnecessary, not because they don't need the lawyer, but unnecessary because they could have protected against it if they had been more straightforward with the patient and explained why they were charging what they were charging for. The legal expense is 100% necessary because under no circumstances should any practice manager, practice employee, or physician be speaking directly with a government agency. And that is really any agency except Medicare when you're dealing with claims payment or Medicaid claims payment issues. And even that is with specifically the claims department. If you're speaking with a special investigation unit or OMEG or a RAC, recovery audit contractor, please have an attorney involved at all times. You just don't know what they're looking for and whether or not you're going to get the practice in deeper trouble. Okay, disclosure of immunizations for our pediatricians listening, our pediatric practices listening. This is a big change. You are now allowed to disclose to a school about immunizations for a student or prospective student, and is limited to the proof of immunizations, and the school is required to have such proof prior to admitting the individual, of course, and the covered entity is required to obtain the documents and agreement for disclosure from a parent or guardian or a person acting on behalf of the individual, and or the individual if they're an adult or emancipated minor. So I hope this helps some of your offices and cuts down some of the time you have communicating with schools. This is a major new requirement. This is what you're all probably waiting for. What do we have to do to our privacy practices? Notice of privacy practices for our patients. Now, this is a form that every single practice listening should have on file. It is required to be available and accessible to your patients every time they come in, and they have to sign off on it that they received it, which is different than them actually taking it home. If they don't want to take it home, they don't have to, but you have to have it on file and available. I recommend having it out in the waiting room. This document must be updated. These are the requirements for the update. If you're going to try to draft it yourself, I absolutely do not recommend that. I also want to caution that I see a lot of doctors' practices every day, and many of you do not have proper notice of privacy practices right now. You do not have the proper breach notification language in there. Many of you have gotten your documents from a state organization or a specialty organization, from an organized medicine organization, and those documents are not correct. They do not read in line with the law, and I know you think that you have the right thing in place because you got it from what you think is an authority, but they have not done right by you, and they do not have the proper documents in place for you to have. So be very careful about what you adopt, and these are things you have to check off to make sure are in here, and it has to contain a statement indicating that most uses and disclosures require authorization, and also this is mandatory authorization now. Psychotherapy notes. Now, even if you do not do psychotherapy in your practice, which many of you do not, there may be a chance that you would have psychotherapy notes in the health record, and that is why every office must have a notice in the privacy practices that complies with the requirements for the new rule for psychotherapy notes. Same thing with marketing purposes. You're required to have a notification to patients about marketing purposes, what you're using their health information for marketing purposes. If you're not using it for marketing purposes at all, meaning you're not taking demographic information and extrapolating that and using it for marketing or more specific, then you can put a notification in your privacy policies that you will not be using it for marketing purposes, period, but something has to be in there. Sale of protected health information also must have a provision in there that addresses a sale of PHI. We have a standard form, which I'll show you at the end, for your notice if you're looking for assistance, but these are the ways that it has to be changed. You are required to notify patients of a change of your notice of privacy practices. This is the same under the old law, but it is applicable now, so I'm going to go over it. You have to maintain the policy in the office, and you have to have the notice available, as we talked about. You have to post the notice in a clear and prominent location, so just put it up or leave it on the front desk or put it up on the wall. And whenever the notice is revised, you have to make the notice available upon request. If you have a website, I would recommend putting it on the website. If you have patient email, you can email it out and click with a link saying here, you can find it here if you want, and document that you did all these things, so that way if you ever looked into, you have it on file. Business associate arrangements are changing under the new rule. These are the things we're going to cover right now. The definition of business associate has changed. The minimum necessary standard will now apply to business associates. There will be agency liability, and contracts are required, which is the same, but we'll talk about contract changes for business associates. First change, business associate, the definition has changed. It used to be a person who performs functions or activities on behalf of the covered entity. It now is a business associate with any person who's creating, receiving, maintaining, or transmitting protected health information. I'm going to talk about this slide a little bit, so I'll leave it up for a minute. Now, let's talk about your internet service provider. They have access to your information. So this new definition is also going to cover people who are managing, administrating, accrediting, or financial services where the provision of service involves disclosure that has more than routine access. So let's say your internet service provider. If they have no access really, if they're just your ISP is just kind of doing their bare minimum and just being the conduit, then they're not going to be a business associate. But if they're coming in and troubleshooting for you and helping you with your EMR, that is more than just routine access, and that person would also be a business associate. So let's go down the list of people that I would, under the law, I extrapolate and say are business associates. This would be a third party that has access to your information and is looking at it. So obviously your billing company is the easiest. Let's talk about your bank. If your bank is really just doing maintaining your accounts and not really accessing, then absolutely they are not going to be a business associate. However, if they're helping you with cash management services and they're coming in and really looking at your records, yes, that is going to qualify as a business associate. If you hire a consultant to come in and assist with documentation potentially, I know some practices do this, yes, business associate, person needs an agreement. People who do not qualify would be a practice employee, other healthcare provider, other covered entity, government agency, or HMO plan or payer that is has another arrangement with you. They would not qualify as a business associate. Business associates are now required to adhere to the business associate, the minimum necessary standard, which means that when they're making disclosures with PHI that you provided to them, it has to be in the minimum necessary possible. There's an easy example to tell you that I've seen this happen where it's not the case. Many of you work with billing companies, and a lot of their contracts require that with each claim they provide, you give them a whole bunch of information on the patient. That is not adhering to minimum necessary. They may not need all that information to process the claim. They may need it eventually to appeal the claim or to provide documentation, but you're giving them a whole boatload of information on the patient that may not be necessary for their intensive purposes. So you want to be careful. Your business associates are going to be required to adhere to the standard as well, and it's going to be very important when we talk about contracts, which maybe I'll do now and come back to agency liability. Business associates are required to have a contract. So every business associate that you deal with must have a contract in place that specifies certain protections under HIPAA. Now, there is a sample business associate agreement online at the Office for Civil Rights. Other law firms have posted that exact agreement online for you to think that they're giving you some sort of value add, that they're providing you this document for free. And I know many offices like to have a document for free. Let me explain to you why it's foolish to use the document that's posted online and also these free documents that are given by certain law firms. In your business associate contract, the HIPAA rule specifically says in this update that we have in January, and when I say the update, I'm talking about the actual changes to the rule, and also the hundreds of pages that are posted explaining the rule called the Federal Register, which I actually read. Most lawyers I don't think bother, but I actually did read it. And buried in that law, it says that you are explicitly authorized in your contract with business associates to shift away liability in your contract. So in other words, we can put indemnification provisions in, meaning that a party would have to step into your shoes and pay for exposure that they've created for you and be held financially responsible, which is awesome. It is an incredible legal concept and so foolish if you do not take advantage of it. These provisions and other protective provisions are not in these standard forms. You have to have a document that's going to protect your interest. If you are the covered entity, you're the medical practice, you need to make sure that you're working with a business associate agreement that says we are only responsible for information that we have created and for obligation that we're willing to take on, which is our maintaining of protected health information. Once we give it to you, business associate, if you screw up, that's entirely your responsibility, and you're required to pay for any kind of mess up that you've created. And you're allowed to do that legally, so why would you not take advantage of that and have a proper contract in place? We're going to show you our prices for contracts, but our business associate agreement, we sell it for $150. It's the bare minimum time that it costs for our lawyers to put it together for you. It's customized, and it has protective provisions, and you'd be foolish not to utilize it. Not going to start from scratch. Obviously, it's a form. That's why we do it for a flat rate. So we'll show you the rates later. But if you're not going to use business associate agreement that has this shift, this burden of proof and shifting liability, then really you are absolutely holding yourself out as a sitting duck for no reason and not taking advantage of a great legal way to protect yourself. Going back to agency liability, covered entities are now going to be held responsible for acts of their agents. So let me give you an example of an agency relationship. Agency is going to be totally stacked based on whether or not the person is an agent, and it's going to be where you have control over that person, and you're going to be instructing their responsibilities. So great example. We hire some college kids to come in and help scan in because we're making our transition to electronic medical records. One of these individuals doesn't really pay attention, accidentally takes a couple of files home, loses their backpack. What happens? The information is discovered somewhere, happens to be Lindsay Lohan's medical file, and maybe it wasn't taken accidentally, and information gets out. Who is going to be responsible for this disclosure? Well, what I'm telling you is the medical practice is going to be responsible because this individual is working completely under your control. All right, so that's an example of agency, and any liability you're going to have from a lawsuit from the Lohans or a civil monetary penalty from the Office for Civil Rights, if this is reported and discovered and you're found liable, is all going to be on the practice. Now, an example where you don't have an agency relationship is with your billing company, for example. A party that you have a contractual arrangement with where you do your part, you create the medical records, they do their part, they're doing the billing, you have no control over how they do the billing, they're a separate company, there's no agency relationship created, it's merely a third party that's doing work for you, and you're not going to be held responsible for that information. Next change is going to be the breach notification rule. This is a major, major change. We're almost through our changes, so hang in there. Major change to breach notification. Used to be a standard of whether or not the individual was actually harmed as a result of the breach. This is now going to be only a factor into whether or not there's exposure and how much money you should be fined. The new change is not whether or not there's actually harm. It's whether or not you actually had any acquisition, access, use, or disclosure of protected health information that is not permitted under the subpart. So, meaning, if any information is set out into the public that is not authorized under the rule, we went over a bunch of ways that it is authorized, but if it's any kind of other disclosure, then it is automatically a breach. Automatically a breach. You're in breach of this rule. And that is substantial and could have massive penalties for the practice, as we'll get to. Okay? Now, that being said, there are exclusions. We're going to go through them right now. So we've had a breach. Does it fall under an exclusion where it's not going to be an area that we have to necessarily disclose or do any kind of internal review? So here are the exclusions for a breach. An unintentional acquisition or access of PHI by a workforce member, someone who works for us and is authorized, okay, or a person acting under the authority of the covered entity or a business associate. So we know these are allowed. These are authorized uses of protected health information. If such acquisition, access, or use was made in good faith and within the scope and authority and does not result in further use of disclosure. So this is proper use of protected health information, not a breach. Not a breach if the disclosure is from one authorized person to another authorized person. So from one doctor's office to another doctor's office, or authorized from the practice to an authorized individual by the patient is authorized to view, that's fine, or to a school, or under authorization. So that's one. Not a breach if disclosure of protected health information where the covered entity or business associate has good faith belief that the unauthorized person would not reasonably have been able to retain such information. So let me give you an example. Billing company that I work with accidentally posted the wrong doctor's office's information to a clearinghouse, and another practice saw the information. They notified the billing company immediately, and the billing company had the clearinghouse take down the information. Was there a breach here? Well, this was another authorized, it's an unauthorized person, but the office let us know that they did not print out anything from the clearinghouse. They did not save anything. The data that they saw was not unique, and they didn't retain anything. No one remembered what they saw, no patient names, no anything. So is it a breach? Well, we'll talk about next whether or not we think it is a breach, because we had to do our own internal analysis, which is what is here. This is what is also required now. Prohibited use or disclosure is a breach unless the covered entity demonstrates there's a low probability that the protected health information has been compromised. So with the example I just gave you, we were able to look at the nature and extent of the PHI involved, including the types of identifiers and likelihood of re-identification. The information posted did include some patient names, but it was mainly just a jarble of information, nothing that anyone would have taken. They didn't really look at it in detail. The unauthorized person who uses it to protect health information or to whom the disclosure was made. In our situation, it was another medical practice that had a relationship with the billing company and is aware of HIPAA rules and adheres to them on a regular basis. Whether the PHI was actually acquired or viewed. Here the PHI was viewed, but it was not retained. So we felt that that was an appropriate situation where we're still covered and we've done our assessment. The extent to which the risk of the PHI has been mitigated. Well, the clearinghouse took the information down immediately, so we felt that it had been mitigated. So we did our risk assessment. I did it with them, so they hired their healthcare attorney to do it. We wrote up an internal review, and we have it on file in case anything does come of this in the future, and we have now protected ourselves. So you want to make sure you're working with your attorney and that you do the proper assessment, you have it in writing, you have it on file. There was something else I wanted to add with you about this. Oh, breach notification. This is a policy that we've done for you to have on file. We'll go through the pricing for it in a minute, but it is very important for you to have. This is for staff training purposes to explain what a breach is and why do we do this. Why do you have to have a policy explaining breach and breach notification? Simple. Because other members of the practice that do not have your level of information and are not listening to this presentation may try to cover up a mistake that they've made. For instance, I've seen plenty of times where information has accidentally gone out to the wrong patient, or, for instance, you print something on an envelope that's going out publicly that should not be there, like a Social Security number, and if a person at the practice makes this mistake, their indication or their first instinct is going to be to not tell anyone. Well, that is going to lead to a whole host of issues for the practice, and we need to take steps to make sure that doesn't come to fruition. And the first step is education. So I'm telling you, you should be required to have a policy on hand that explains what a breach is, what happens if there is one, and you have to bring it to the attention of your immediate supervisor immediately, and it needs to be addressed properly. Or else, you're going to be subject to the new enforcement provisions, which we're going to talk about right now. Under the new rule implemented in January, retroactively, for violations after February 19, 2009, the Secretary will, this is how it reads, will impose a civil monetary penalty upon a covered entity or business associate if the Secretary determines that the covered entity or business associate has violated an administrative simplification provision. Now, what does that mean? An administrative simplification provision is any requirement under HIPAA. So now the rule has been changed. It used to read that the Secretary may impose a fine. Now it has been changed to will impose a fine if you are in violation of any rule under HIPAA. So that includes a security rule for electronic maintenance of information, the privacy rule, which we've been covering, and the breach notification, which we just covered. So big change. What is the significance here? Well, this office that looks into HIPAA compliance, the Office for Civil Rights, used to be the nicest office in the government that I had to deal with on your behalf. Meaning I would get an individual on the phone, the individual would be reasonable, and I would be able to speak with that person and come to a reasonable resolution for your matters. This office has now gotten a new mandate, and that is to be stricter, to do compliance reviews, to investigate, and to fine. So we are now going to be dealing with a different Office for Civil Rights. They also are now told that they will be imposing fines instead of may. So this is a significant change, big deal for the practices. They're going to be cracking down, and we're going to be seeing a lot more audit activity, let alone not just complaints being investigated, but actual audit activity by this practice. Why? Because there's money here from them. So I don't mean to give a depressing message. I know everyone is bummed out enough by what's going on in healthcare, but another agency is going to be coming in to look to see whether or not you're adhering to their rules. So the easiest way to avoid any kind of imposition of a fine or exposure is to just be compliant. And for your practices out there, that's going to mean you're going to have to spend a little bit of money on this. You're going to have to make sure you're trained properly and that you have the right policies and procedures. And for those of you out there who are looking for doctors to say, oh, you just put this in place yourself, you really have to understand that preventative medicine, just like they're preaching to their patients, is always the best medicine. Losing weight and exercising regularly for a diabetes patient is obviously going to be a lot more beneficial than waiting until it's time to sever a leg. So it's the same thing here. Preventative medicine, you have to make sure you're getting this stuff in place. First step is listening to the webinar and getting your documents in place. Changes to civil monetary penalties. This is what's been implemented. We're going to go through them very quickly. There's 4 different levels. The level of exposure changes on your level of exposure and liability. So how badly did the practice screw up, and what did you do to fix it? And that's going to change what you're going to be responsible for. So first level of violation is the lowest. It's where you did not know and really wouldn't have known that you did something wrong. Unless the Secretary decides otherwise, you could be imposed a fine of not less than $100 or more than $50,000. Whoa, Jennifer, that's a huge difference, $100 versus $50,000. What's the deal here? Well, keep in mind that hospitals and major conglomerates, as well as the solo doc practice, are under the same rules, and we are going to be fined a lot less for a small practice than for a hospital, because a hospital slap on the wrist, $100 is not really going to feel like much. So that's why we have up here to $50,000. And we'll get to how to mitigate these fines in a couple of minutes also. Second level violation was due to reasonable cause and not to willful neglect. So this is where an act or omission by the practice in which a covered entity knew or would have known that they were violating a provision, but did not act with willful neglect, and we'll get to that. So you knew you did something wrong, and or you really should have known, and you did it anyway, and you're going to be penalized not less than $1,000 or more than $50,000 for each violation. So let's talk about the practice that accidentally put the Social Security number on 100 envelopes and mailed them out before they realized that their Excel labels were printing incorrectly. Well, that's what I say, 100 envelopes went out, so that's 100 different instances. So that's a lot of money if they decide to fine you for a violation here. So just be wary. Third level, we're getting higher here. This is where you did something really wrong and you should have known it. Willful neglect means a conscious, intentional failure or reckless indifference to the obligation to comply. So you knew what you had to do, you ignored the obligation, and you did so with a reckless disregard, and you're going to be fined here a substantial amount of money. This is where you actually timely corrected the egregious violation. So you're going to be fined at $10,000 or not more than $50,000 for each violation. Now, this is the third level. What do you think the fourth is going to be? It's going to be exactly this, but you didn't timely correct. So this is where you had absolutely reckless, wanton behavior, total indifference. You haven't adopted any policies. What's HIPAA? Who cares? We post our patient information all over the place. It's not secure. And you didn't timely correct this. So this is a big deal. You've done a lot wrong. No one on this webinar is going to be doing this because you're listening and you're not acting with this kind of reckless indifference. Not less than $50,000 per violation, and except for the penalty under any category may not exceed $1.5 million. Now, this is for each violation, don't forget. So it could really rack up even more than the 1.5 if you're a big hospital. Civil monetary penalties. We are no longer going to have an affirmative defense for not knowing that we did something wrong. That is gone, okay? We do have on our side that there's a prohibition on penalties for any violation that is corrected within a 30-day period as long as it was not due to willful neglect. So we have that on our side. Also, there will be no double dipping by the government. If you're held responsible for violating the Patient Safety and Quality Improvement Act, you will not be penalized under both, one or the other, not both. So that's good news, too. Factors considering and determining whether or not they're going to impose a fine, nature and extent of the violation, individuals affected, time period when it occurred, nature and extent of the harm. Remember, the harm used to be our only standard. Now it's just a factor in determining what we're going to be penalized. Did the violation cause physical harm, financial harm, harm to an individual's reputation? Did it hinder the ability to obtain health care? These are all things that are going to be taken into consideration. History, prior compliance, financial condition of the breaching party, financial difficulty to comply, and size of the entity, all going to be taken into consideration. Now, whether or not you're going to be fined, there's going to be a whole investigation process, and you're going to have counsel, I would hope, and you're going to present your case, and you're going to defend yourself, and you're going to argue your factors on why you wouldn't be fined and what you did right as opposed to what you did wrong, and carefully you work with. This may be covered under an insurance policy that you might have. You may want to make sure that you have a policy on this. We offer a prepaid legal plan where you can pay in advance a minimum amount of money and you get substantial benefit. It's $500 a year, I believe. We'll look at it in a second. And if you are a member, you get substantial benefit. We give you policies included in that year long, and special updates that are not in the newsletter. And we really take care of you guys and try to make sure that we can get rid of this stuff as quickly as possible, because we don't want to. This isn't what we want to be. We're happy to help you and we're here to help you, but this is what we would prefer not to be seeing you involved with. So we do offer extra protection for you for these types of matters. Penalty considerations, again, we just went through the factors, but the Secretary always has the discretion to settle, and that's what we would be negotiating with them for, to try to get you out as soon as possible. Compliance reviews. The Secretary is going to be doing compliance reviews and looking to see whether or not you're complying to fine you. Why would they want to do that? Well, they're broke, the government's broke, or they're claiming they're broke, trying to eat down that billions of dollars, hundreds of billions of dollars of deficit, which they are eating into, thanks to the audits and thanks to you. We are no longer at $1 trillion anymore, if you read the news, and they're going to keep chomping away at that deficit, and they're going to do it by fining and taking money from private companies that are earning it, and that's the unfortunate reality. So we want to make sure we have all our policies and procedures in place, because I can tell you when they do a compliance review or when they are investigating a complaint, the first thing that they do is say to you, let me see your policies. So we have to be really careful and get that up and make sure that we're in compliance. Agency share. This is really important. The Office for Civil Rights used to keep whatever you gave them confidential. That is not the case anymore. That is not the case anymore. They are now authorized to share with the Department of Justice, with Medicare, with whoever they feel like. They can say, look, we found this practice. They didn't have their HIPAA stuff in place. We also looked around and things just don't seem so kosher. You may want to take a look at this place. And they're allowed to do that now. It's totally authorized. So just be really careful, and we don't want to end up on their radar. We also want to control the flow of information when we are on their radar, which is why we do not speak to them. We call our attorney immediately. Summation. The new law is changing requirements, liability, and enforcement. We went over all of these. Covered entities and business associates need to update right now their policies, procedures, and potentially all of their contracts. The contract that you're going to adopt for the business associate agreement can be a form you're going to use with all different types of business associates, but you need to get a new one now, and you need one that's going to control who's responsible for what. It is imperative for you to review all of your relationships. If you need help with this, call me. We can talk about it. You don't get a bill when you call me for a consultation. You get a bill when we take on work, and we're going to be doing some major changes for you. So feel free to call me and we can discuss. Questions, obviously, you can participate in questions because this is a one-way webinar. So if you have questions, send them to me. Send me an email. We're going to go to the website in a second. This is me. Here's my email. You all have it, or you should have it. If you're not in the newsletter, sign up. I'm going to show you our website real quick just to show you where you can go for resources. So if you haven't been to our website, this is our website. Okay? This is a healthcare page, and it talks about our practice areas, and it also, so you can learn all about the practice areas and what you should be looking for help for. You can meet our team. This is our prepaid plan, which you can click on and see the specifics. If you click right there, or if in any of the newsletters you click on it, it'll explain to you our whole program, tells you exactly what you're paying for, and I like to be very transparent in all billing, and that's why we do the plans. You know what it is. Here it is, Office for Civil Rights, covered, okay? So we cover up to 3 hours of attorney time. Why do I do 3 hours or say it in the plan? And if it's 4 hours, you can get an additional bill? No. 3 hours is typically enough time to either resolve the matter entirely or understand completely that we are in for the long haul, and we develop your strategy. We tell you exactly what's going to be, and we give you time to make an educated decision about whether or not how we're moving forward and what we're going to be doing. So That's what the plan is for, is to get a real handle on what's going on, put our best foot forward, make sure we can mitigate, try to get you out of it within the time. 3 hours of time, by the way, is going to be at least $900 at our firm at a minimum. So you're getting a rate here that's much lower, and you get all the additional compliance work we're going to do for you for free or included. So you want to be, if you want to be protected, I would recommend that you sign up. We do a good job of protecting our clients. So our newsletter, many of you are already on the list, but if you're not, sign up. You can sign up right here on the website, and it goes right into for you to be receiving our weekly newsletters. They're all posted here, and as you can see, we do a lot of information for you, and we'll be happy to help. The next thing I wanted to show you is our, sorry, I have to, because of the webinar information on my screen, I can't go back there. So the next thing I want to show you, and this is most relevant to our talk that we just did, we do all of our compliance forms at a flat rate. Here's a legal plan. This is the order page for our firm. Here are all the compliance documents if you need anything else, but you can feel free to look at this after the webinar. Here's the HIPAA compliance forms. Whoops, and what I just did is not going to let me go back up. Sorry about that, but you can see here that we have all of our forms, and I recommend that you look at each of them. I do a detailed explanation of what they are. If you're not really sure, you can email me again. Notice the privacy practices. This is to cover you for everything. Okay, what we just talked about, all the changes. We do it for a flat rate of $140. Why do we do that? Well, I bill you $300 an hour, so this is just taking the time to customize it for you for your practice, and we send it out, and you're all set. Security policy, which is required. A lot of you don't have it. You can maybe get this from your EMR company, so if you want to call them first and see if they have it, please feel free. If they can give it to you for free, I'm not looking to charge you for it. Red flag policy, this is protecting your practice against identity theft. It's instructions for your front desk staff, what they should do before giving information out to a patient. It's important. It's not required, but it is important. So if you want that, we have that as well. Breach notification, I think every practice should have this on file. Customize it for you. And by the way, the customizing, if you call me up and you say, Jennifer, I really want this incorporated, I'm not going to bill you for that time. I don't bill you for the changes, but I do bill you for the policy because we got to take the time to put it together, and we have to customize for you. These additional things are all recommended, not required, but your consent for disclosure, this is absolutely, I believe actually is required. You want to make sure you have a comprehensive form for patient consent where the patients are giving you their email address and telling you can communicate with them, if you can leave voicemails for them. Most of you have it, but you may want to tighten it up a little bit. You may not have it as cleanly as we've written it, and you may want to modify it. We do that for $65. Financial policy, this is maintaining credit card information on file, explaining to the patient that they have to pay for your services. They're financially responsible at the end of the day. I recommend every practice have this. I know your patients don't want to pay you, but they're happy to pay for new iPhones. So you want to make sure that they're willing to pay you as well. This is required. This is a packet, basically. It doesn't come in packet form, but it's about 10 or 15 policies that we know are required by the Office for Civil Rights. How do we know that? Because we deal with them on a regular basis representing clients, and they tell us you must have access to medical records policy on file. You must have a certificate, an amendment document policy on file for patients. So we give you all the policies that we know are required, and it's a flat rate. It's about 10 or 15 policies. Here's your business associate agreement with your indemnification provisions and risk sharing and everything else you want us to put in there. We're happy to customize it for you. Flat rate, $150. You get it all. And look, all this stuff, we do this for you at this price, not because we're even making money on it, just to cover our costs, because this is stuff I want you to have in place. We do a full package for $750. You get all this stuff I just mentioned, and that's it. That's the information I have for you on this topic. Again, for those of you who don't know me, I'm Jennifer Kirschenbaum. I manage our healthcare firm, practice at the firm. We have 14 attorneys. You can look at all of our practice areas on our website, which again I cannot get to because of this webinar information on my screen. And these are our general practice areas. We have a lot of different areas. We have an excellent staff. We have 14 attorneys. We have Judge Ruth Kraft just joined us, helping with labor, and you'll be seeing some webinars available for her. And the main way to get your information is, of course, to sign up for our newsletter, which is very simple to do right here. We have 3 different newsletters. You're welcome to participate in any of them. The employment law is very excellent. It's very general information, though. It's not necessarily healthcare specific. You will get employment and labor and trust in the states and everything else that's relevant to healthcare on the healthcare newsletter. Just put your email right in there, click submit, and we'll add you. Hope this information was helpful. And any questions, feel free to reach me at any time. And I hope everyone has a great day. Bye-bye.